carved in stone, but unfortunately or fortunately, we live in a real world, so there is a continuous tension between human behaviors and laws, trying one to overcome the other and vice versa. Thank you for this overview, critical and evolutive on the regime of the continental shelf. And now it's the turn of our second speaker, which, on the contrary, will focus on recent developments concerning the legal regime of the continental shelf. Our next speaker is Professor Bjarni Magnússon of the Bifröst University in Iceland. In this university, he is the Dean of the Faculty of Law. Professor Magnússon is deeply involved in studies, but also in active engagement, and in particular, he has recently been appointed to the Iceland Climatic Council and participates in the Icelandic government's working group tasked with preparing submission to the Commission on the Limits of the Continental Shelf. So he's an expert since many years of the outer limits of the continental shelf. Please, the floor is yours, Professor Magnússon.
Thank you for the introduction. Excellencies and distinguished guests, I want to express my deepest gratitude to the organizers for inviting me to participate in this esteemed event. Their dedication and careful attention to detail have clearly created an outstanding platform for discourse on some of the most pressing issues in the international law of the sea. I'm particularly honored to be part of this distinguished panel with world-leading experts in the field, including my longtime friend and colleague, Ki-Bom Lee. Our professional and personal journey began during our PhD studies under the guidance of Professor Alan Boyle at the University of Edinburgh about 15 years ago, with Ki-Bom specializing in maritime boundaries and myself focusing on the delineation and delimitation of the continental shelf beyond 200 nautical miles. This event not only fosters critical discussions, but also renews bonds that have shaped our careers, and I'm truly thankful for the opportunity to be here. Although my recent professional efforts have been focused on leading a faculty and working on the merger of two universities in Iceland, I'm confident that I still can contribute meaningfully to today's discussion. My presentation builds on ongoing collaborative work with Colter Lathrop and Kevin Baumert. I need to note that Mr. Baumert is collaborating with us in his personal capacity, not as a US governmental official, and I should probably say as well that I'm here as myself, and I do not represent anything else. But together, we are developing an analysis of recent developments concerning the continental shelf beyond 200 nautical miles. As many of you know, the judgment of the International Court of Justice from 13 July 2023 in the maritime delimitation case between Nicaragua and Colombia has generated substantial debate regarding the legal relationship between the exclusive economic zone and the continental shelf, prompting questions about the evolving principles that govern maritime boundary delimitation. In essence, the question is about the role of the 200 nautical mile limit in maritime boundary delimitations concerning the continental shelf. In its judgment, the ICJ held that under customary international law, a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of its territorial sea is measured may not extend within 200 nautical miles from the baselines of another state. Referring to continental shelf beyond 200 miles as extended continental shelf, the court further elaborated that even if a state can demonstrate that it is entitled to an extended continental shelf, that entitlement may not extend within 200 nautical miles from the baselines of another state. Thus, the continental shelf within 200 nautical miles, along with the waters above that are part of the exclusive economic zone, it takes precedent over any extended continental shelf entitlement according to the court. With this legal determination, the court resolved the case in Colombia's favor. At the same time, the court introduced uncertainty into small but important continental shelf entitlements across the globe. Dissenting and separate opinions reveal divergent perspectives from the majority, indicating that the ICJ ruling may not fully align with established theories and prevailing international practices. In my presentation here today, I'm going to deepen some of the comments Professor Evans made, and I'm going to argue that the court's holding is not an accurate reflection of the current state of customary international law. My focus will be on the evidentiary basis of the court's judgment, including with reference to the continental shelf announcement made by the United States in December 2023, which postdated the court's judgment by 5 months. So, in December 2023, the United States, a non-party to UNCLOS, announced its extended continental shelf outer limits in 7 different regions. The legal basis for this announcement was customary international law. In 3 of those regions, the Bering Sea, Arctic Ocean, and Atlantic Ocean, the United States asserted extended continental shelf within the 200 nautical mile limits of a neighboring state. These areas are depicted in the maps on the screen. Although these areas are small, they are nevertheless inconsistent with the court's July 2023 holding. In considering the broader state practice pertinent to the court's holding, it is useful, or can be useful, to split the relevant practice into 2 categories. First are assertions of extended continental shelf, like the one made by Nicaragua vis-a-vis Colombia, namely assertions that are major intrusions into the 200 nautical mile zone of a neighboring state. For convenience, we call these type 1 assertions of extended continental shelf. Aside from Nicaragua, there appear to be only 3 other such examples worldwide: China and the Republic of Korea, both vis-a-vis Japan, and Somalia vis-a-vis Yemen. I will come back to this category after I address what we can call type 2 assertions of extended continental shelf. Type 2 extended continental shelf assertions are more minor in nature. These situations are typically apparent in maritime boundary delimitation contexts where neighboring states have either already established a maritime boundary that is not based on equidistance or, alternatively, have not yet established a boundary. The US examples that I have shown on the maps are type 2 extended continental shelf assertions, and how these situations arise is instructive of broader global practice of states. In the Atlantic Ocean, the area marked 1 on the map on the screen is an area of US extended continental shelf within 200 nautical miles of Canada's baselines. It lies seaward of the existing US-Canada maritime boundary, which was established by a chamber of the ICJ in 1984 in the Gulf of Maine case. That existing boundary, which terminates 200 nautical miles from the US coast, is not equidistant from the coast of the United States and Canada. And the 2 countries have not yet agreed on a boundary in more seaward areas. Area 1 arises because of two factors. First, the existing non-equidistant boundary, and two, the manner in which the two countries have delineated their extended continental shelf limits seaward of that boundary. The United States delineated its extended continental shelf by extending the existing boundary in the seaward direction along its same trajectory. For its part, Canada used an equidistance line as its lateral limit with respect to the United States. As a result, an area of U.S. extended continental shelf extends within 200 nautical miles of Canada. In the Arctic and Bering Sea regions, areas 2 and 3 lie on the U.S. side of the U.S.-Russia maritime boundary agreed in 1990. Those areas are nevertheless within 200 nautical miles of Russia's baselines. Type 2 extended continental shelf assertions are commonplace. Indeed, several more are visible in the map on the screen. Area 5 is an area of Russian extended continental shelf that is within 200 nautical miles of the United States. Of note, this area lies within Russia's continental shelf limits that were reviewed and favorably recommended upon the Commission on the Limits of the Continental Shelf in 2002. Neither that extended continental shelf nor the ICLS recommendations have been questioned. These type 2 extended continental shelf assertions are appropriate in the context of boundaries that have either already been concluded, like US-Russia, or not yet concluded, that is US-Canada. Additional type 2 extended continental shelf assertions abound worldwide. In the Americas and the Arctic, for instance, they have been made by Argentina vis-a-vis Chile, Brazil, vis-a-vis both France or French Guiana and Uruguay. And Russia vis-a-vis Norway, as you can see here, and Uruguay vis-a-vis Argentina. In many cases, it's not entirely clear based on the geography where a state is making a type 2 assertion. This would include France extended continental shelf vis-a-vis Canada and Venezuela's vis-a-vis Barbados. A full global review is beyond the scope of this presentation, but the point is that these situations are not necessarily unusual or extraordinary. Type 2 extended continental shelf is also evident in decisions of international courts and tribunals, as President Heydar mentioned previously today, including in the two cases in the Bay of Bengal decided under the Convention's dispute settlement procedures. In its 2012 judgment, the International Tribunal for the Law of the Sea established a boundary between Myanmar and Bangladesh that resulted in an area of Bangladesh's extended continental shelf within 200 nautical miles of Myanmar, that is within Myanmar's EEZ. Similarly, in 2014, an arbitral tribunal in a case between Bangladesh and India established a boundary that resulted in an area of Bangladesh's extended continental shelf within 200 nautical miles of India. In both cases, the tribunals referred to these as gray areas and importantly affirmed the continental shelf entitlement of Bangladesh in the gray areas, notwithstanding the location within the 200 nautical mile EEZ limits of neighboring states. In its 2021 judgment in the maritime delimitation case concerning Somalia and Kenya, the ICJ noted the possibility of a gray area within which Kenya might have extended continental shelf entitlement within the EEZ of Somalia. Although the court's July 2023 judgment binds only the parties to the case, its holding declared a rule of customary international law. If this rule is correct, it would preclude not just type 1 extended continental shelf, but also type 2. The view of the court that the state's extended continental shelf entitlement may not as a matter of law, extend within 200 nautical miles of another state is incompatible with gray areas and all Type 2 extended continental shelf assertions. What makes the court's holding especially puzzling is that the court seemed untroubled by Type 2 extended continental shelf assertions. The court's discussion of the Bay of Bengal cases is telling in this regard. According to the court, those cases are of no assistance with respect to the case concerning Nicaragua and Colombia. The court dismissed these Type 2 situations as incidental results of boundary delimitation. Although this may be true with respect to the gray areas, the gray area itself can only exist if Bangladesh has extended continental shelf entitlement in the first instance. Boundary delimitation, as ICLS stated in its 2012 judgment, presupposes an area of overlapping entitlements. A boundary divides overlapping maritime entitlements. Those entitlements do not arise from the creation of a boundary. In reaching its customary international law conclusion, the court referred to the state practice of both convention parties and non-parties. The treatment of both groups of states appears problematic. With respect to convention parties, the court states that the vast majority of states parties to the convention that have made submissions to the CLCS have chosen not to assert therein outer limits of their extended continental shelf within 200 nautical miles of the baselines of another state. This means that the ICJ interpreted submissions to the CLCS as evidence that states do not assert extended continental shelf rights within another 200-mile zone. Yet, I must caution against seeing this as proof of customary law. It is highly likely that some states avoid such claims not out of legal obligation, but rather due to political sensitivities or strategic reasons. Even assuming that submissions to the CLCS, which pertain to a treaty-based procedure or probative of the existence of a rule of customary international law, the court's focus on extending continental shelf outer limits is misaligned with its holding, which pertains to extending continental shelf entitlement. The two are not the same. The court seems to assume that if a state's extended continental shelf outer limits do not encroach within 200 nautical miles of another state, then neither does its extended continental shelf entitlement. The US and Canada examples I mentioned previously are illustrative of how this is often not the case. Neither country asserts extended continental shelf outer limits within 200 nautical miles of the other, but both assert areas of entitlement within 200 nautical miles of the other. A more fulsome geographic evaluation, including with respect to the inner limits and lateral limits of a state's extended continental shelf, is needed to determine whether extended continental shelf entitlement is asserted within 200 nautical miles of a neighboring state. This is tedious work, but when it's done, a large body of state practice, specifically Type 2 extended continental shelf assertions, can be identified that raises doubts about the rule of customary international law identified by the court. With respect to non-parties, the court states that among the small number of coastal states that are not states parties to the convention, the court is not aware of any that has claimed an extended continental shelf that extends within 200 nautical miles from the baselines of another state. Searching for claimed extended continental shelf presents an evidentiary conundrum, since under both treaty and customary law, entitlement to continental shelf need not be expressly claimed. This is clear from UNCLOS and ICJ's North Sea continental shelf case. Even leaving this aside, the court seemed to overlook the practice of two non-parties, the United States and Venezuela. Long before the court's 2023 judgment, Venezuela and the United States had each made its views known to the international community, that it is entitled to extend the continental shelf on the basis of customary international law. Given Venezuela's repeated assertions of extended continental shelf entitlement, along with its maritime boundary with Trinidad and Tobago that extends beyond 200 nautical miles, it would be difficult for Venezuela's extended continental shelf entitlement to not reach within 200 nautical miles of Barbados. The U.S. extended continental shelf announcement of December 2023 indicated that whatever assumptions the courts may have made regarding how the United States views its extended continental shelf entitlement were not correct. Whether framed as claims or not, the United States, and seemingly also Venezuela, have asserted extended continental shelf rights within 200 nautical miles of neighboring states. The identification of a rule of customary international law must be predicated on evidence of the general practice of states undertaken out of a sense of legal obligation. The view that the community of states has accepted a legal rule that precludes an entitlement to extended continental shelf within 200 nautical miles of another state, and that states have conformed their practice accordingly, is not well established and supported by the evidence. Type 2 extended continental shelf assertions appear to be commonplace and generally accepted by states, including by two international tribunals. Understanding this practice of states requires a deep dive into the geography of each state's assertion of extended continental shelf, and not merely an examination of CLCS submissions or express claims. It is perhaps more understandable that the court was troubled by Nicaragua's extended continental shelf assertion. Like other type 1 extended continental shelf assertion, it is bold, and someone would even call it unneighborly. Perhaps it is also unlawful. If it is, however, it is likely due to a rule of customary international law that differs from the one pronounced by the court. One of the consequences of ICJ's decision is that it opens a new chapter for the disputes in the East China Sea. Arguably, ICJ's ruling puts constraints on the states involved to assert continental shelf rights beyond 200 nautical miles within another state's 200-mile limit, in the sense that one party can always refer to the ICJ judgment to back up its position. One could argue that the ICJ's decision enhances predictability and provides further clarification of the legal regime governing the continental shelf beyond 200 nautical miles. While this may hold some truth, such a development must be underpinned by sound and robust legal reasoning. It is worth recalling that during the third United Nations Conference on the Law of the Sea, numerous states advocated for a connection between the 200 nautical mile limits of the EEZ and the continental shelf. In this context, it is reasonable to view these judgments as a step toward that alignment. Furthermore, from a broader perspective, this decision can be seen as yet another shift away from the concept of natural prolongation, or as Professor Evans called it, half-death of natural prolongation. So, to sum up what I've been saying here today, the ICJ's determination on customary international law lacks a strong theoretical foundation and is not adequately supported by state practice, which does not substantiate the conclusion that a coastal state is prohibited from extending its continental shelf rights beyond 200 nautical miles from its baselines to overlap with the rights of another coastal state within that range. It would be highly interesting to observe how ICLS might approach the same question previously addressed by the ICJ, should the tribunal have the opportunity to consider it in the future. Thank you all for your attention and for allowing me to share my and my colleagues' thoughts and insights. I look forward to the upcoming panel discussion and to hearing your valuable perspectives on these important issues. And I look especially forward to hear Sir Michael Wood disagree with everything I said. Thank you very much.
Thank you, Professor Magnússon, for your in-depth analysis of the last ruling of the ICJ in the case Nicaragua versus Colombia.